Karl, about the issue with the courts, the judges not having oaths of office bonds and get his...
That's easy. Just probably 99% of them don't operate under that because administrative tribunal hearing officers. That's all they are. The really long way of saying it is civil administrative tribunal hearing officers. You find them a lot in Australia, stylized exactly like that. But here we call them judges. In England, they call them magistrates.
Now, what's the best argument against them presiding over a case?
If you want to go an administrative hearing, that's fine. I mean, there's nothing wrong with going into an administrative hearing if you believe that it's 100% in your favor. But if you want to pin them so where the other side can't open their mouth and say anything, that's when you drag them into a common law court of record. But an administrative hearing, like I said, they don't have to. Now, I've been asked many times to sit down here for workman's compensation and lawful termination hearings. So there's 5 of us that sit on a panel. I'm not under no constitution. I don't care if this clown starts yelling up and down, hey, I want my constitutional rights back. Dude, it's an administrative hearing, dude. Dude, nobody here took an oath of office. Do you take an oath of office? Are you going to pay me here? No. You're not going to be here either. What are you talking about?
They present themselves to be a court of law, so we're walking into a, quote, court of law with a person who is an imposter.
Did you ask them?
Imposing as themselves as a judge.
Did you ask him, is he a magistrate, a hearing officer, or what capacity is he? He's wearing a black robe. Yeah, great. But did you ask him what kind? Like my sister went to court one time. She was being sued. I said, the very first question you asked the judge, is this a common law proceeding, or is this is a civil administrating hearing? Which one is it? Which one is it? And the man said it's a common law proceeding. So I said to my sister, you got it. And I walked out of the courtroom. I said, you know what to do in a common law. You'll be done in 10 minutes. She was done in 5 minutes. She was done. There needs to be an injured party on the other side. If there's not an injured party that comes on the other side, then we are not in a common law proceeding. We're in an administrative hearing. There's no corpus delicti. There's no injured body. So if you want to come under some sort of crazy civil code, administrative code, or something like that, Social Security can come after you because now you're in an administrative hearing. You want to benefit from Social Security? Well, then you better believe you better take them into administrative hearings. You want to try to drag them into? You have no right. That's what I'm trying to tell people. The Supreme Court made a couple of rulings when people tried to drag Social Security into common law courts back in the 60s. And the Supreme Court said, you have no right to that trust. You have no right to that fund. You have no right to that Social Security Act. That is not yours. And everybody wanted to believe it was theirs. It's like, no, you're the beneficiary. You're not the trustee. You're not the trustor. You're just a beneficiary, and you can be denied at any time.
In my recent bankruptcy, I challenged her jurisdiction. She never responded. I challenged it again. She didn't respond, but I got a letter from the United States Bankruptcy Court telling me the documents I requested could be obtained from Honorable Thomas Hogan and gave the address in Washington, D.C. I wrote him. I didn't get an answer. I got a little nasty. 2 months later, I wrote a second letter, and I sent it certified mail, and demanded an answer within 15 days. Either supply the documents or tell me why they could not supply the documents. I got no answer. I've gone into the paper with a notice, public notice, that she has no documents. Prima facie evidence, and not produced. Prima facie evidence, they don't have them.
Okay, like I said, when somebody asked me to sit to hear a workman's comp case or a wrongful termination case, I'm not on any oath. I have no bond. You agreed to come to this hearing. You're the one who asked us to sit and judge your claim. Who are you now to say, wait a second, are you petitioner? You claim you brought me here.
Yeah, but she puts the title judge with her name. She says she's a United States Bankruptcy Court judge. She signs her orders. Judge so-and-so.
Well, like I said, the word judge, we use it so freely in this country, it's scary. You can say like the, American Idol judges. See, this is where people misunderstand. The only people that can judge you is a jury of your peers. They're your judges in this country. Now, in England, those guys who wear those big fancy wigs, they're called magistrates. And if you etymologize the word magistrate, the magistrate was just a guy who filled up the wine glasses at the king's court. He kept everybody in court happy. He made sure everybody got whatever they needed. That's a magistrate. That's the role of the clerk of the court, the magistrate. Now, if you want to call him a judge, to let them judge over you, well, that's your peril. Why didn't you ask for a jury? Why did you say
I have asked for a jury.
Okay, like I said, you got to be really careful because the United States court rules, if you ask for a trial by jury under the Article 7, you'll get it. If you say you want a jury trial, you won't get it. I mean, it's ridiculous how they play with these words.
Now, when I use trial by jury, I use the words in the Article 7.
Okay, so then if you said it exactly like that, and did you try to evoke the Ninth Amendment and just say I have the rights that predates this hearing tribunal and I'm entering in today, that if the matter is over $20, I have the right to have this matter judged by a member of the 12 jurors?
Yes, I have, and I've had no rulings. No, she's continuing to act as if I never have done it. She's actually called a hearing for the 30th of this month.
Okay, so did you say to her, like, did you give her? So did she create an order?
Creating what?
Did she create an order yet? Did she order you to appear? Did she order something?
It's an order setting the date.
Okay, so like I said, to me, when I look at it this way, when anybody tries to order you to do something, you have to say to them, what gives you the authority to order me about? You know, when did I give up? Like you said, you were the plaintiff in this. You said you were the complaining party, right?
Well, I am in some adversarial proceedings. I'm the plaintiff, but in the bankruptcy, I'm known as the debtor.
Oh, well, then the debtor is a slave, is a defendant. He's got no rights.
Right. As the defendant, he has no rights. So you have of a plaintiff. I did the adversary proceedings. Proceedings. I got a couple of them going, 3 of them, I think. And
anytime you're a defendant, you got to realize you have absolutely no rights. Then you're going to get clobbered like a ping pong ball.
Right.
So what I always tell people is, you have to file a claim against the other party that they're interfering with your rights to a trial by jury, or they're interfering with your rights to have a common law court of record trial proceed over this matter. So you actually turn around and sue them. You can sue the judge. You can sue everybody who's interfering with your rights to have a 7th Amendment, or Article 7, jury trial by jury under the common law, under the court of record. You can turn around and sue them that they're stepping outside of their authority, scope of authority.
That's known as an adversarial proceeding in bankruptcy. Unless you're going to take it out of the bankruptcy and file it in federal district court.
Right. Well, like that's what I try to say to you. I don't use fancy words like adversarial proceeding. I just say, you are doing me wrong. You are interfering my right. Stop interfering my right, or I'm going to drag your butt into a common law court of record, and I'm going to be compensated for every second that you interfere in my right. And I want to charge you $1 a second. And right now, you're up to 8 million seconds. So how are we going to play this?
Well, I've already done that in the court of record through the newspaper notice.
Well, like I said, the notice, to me, why can't you just propose it to the other side on one page, give them the notice that if they don't stop interfering with your rights, that you're going to charge them $1 a second for every second your rights, or $1 a day, or $10,000 a day for every day that they're interfering with your right to proceed with this matter under a common law court of record in front of a jury. See what they have to say. But you'll never win as a defendant. You'll always get clobbered. You'll always get beat. You have to drag them in. You have to drag them before a common law court of record.
Well, I'm the plaintiff in the adversarial proceedings, whether you like it or not. That's what they are in bankruptcy. Any side case, any issue anything you have an issue with, becomes an adversarial proceeding. You file it as and then you become the plaintiff.
Okay, well, you see what you're still saying? You're still using words bankruptcy court. I don't move under any other court. You will never get an answer from me. I will never file any motion, any pleading, any petition, any answer in anything other than a common law court of record. That is the only court that I believe has the authority to judge me, because nobody else has got the power other than 12 people to judge me. The man in the black robe is a magistrate. He is not a judge. In America, we call them judges for some godly reason I don't know. Go to England, they're not called judges. They say, you see that jury box over there? Yeah, that's your judges. You see the man with the big wig and those 2 guys sitting there with the little wigs? Those are your magistrates. The judges are over there. Talk to them. In this country, we got it backwards. For some reason, the guys on the black road, you keep calling them judges. If they want to call themselves judges and confuse you and trick you and you want to believe their nonsense, God bless you. They don't trick me. I say, wait a second. Can I appeal this? Yeah, well, then I'm not in front of a common law court of record because on the 7th Amendment says that once it's been tried by the jury, it cannot be reheard or retried by any court in the United States. Are you telling me I don't like the decision from you today, I can appeal it to somebody else? Yeah. Well, then I'm in the wrong court.
Is that not what a newspaper notice is?
I don't play that newspaper. I know exactly what you're trying to say with newspaper notices, but you know and I know that's not fair. You can't put it in the obituary in a little tiny newspaper in the middle of nowhere. That might have been fair and square back in 1602 when everybody really read a newspaper, but now when the readership is down to less than 1% and nobody's going to read the notices by the obituary, that's not really fair. So I just tell the other side straight up, look, you interfere in my right. I want a common law trial by jury. Is there some godly reason why you have some sort of lawful excuse why I can't evoke the 9th article of the Bill of Rights and get myself in front of a jury? Tell me your legal lawful determination decision. I don't care what you use to try to explain the nonsense that you're trying to deny me. You can't interfere with the rights of man. You're here to protect the rights of man. You can't be the one interfering with my rights. Heaven help you if you do. I'll charge you $10,000 a day.
Now, is that a contradiction when you said as a defendant you have no rights? Can I do that as a defendant?
No, because you are the ingredient. You are just a little tiny pea on nothing in their case. You have that actor's role of the court jester. You're the clown. You're the Punch and Judy. You're the one.
And in the adversarial proceeding where I'm the plaintiff, I do have that right.
No, because again, you keep saying adversarial proceeding in a bankruptcy court. I don't know the rules. They can change the rules on you tomorrow. Yet those rules for a bankruptcy court or an equity court or a maritime court or whatever adjective you want to put in front of it. I just want to go into a common law court of record. That's the only thing I only want to hear. I don't want to hear. If I hear anything else but a common law court of record, you're interfering with my rights. Well, we're going to take you to maritime court. I don't want. I'm going to take you to tax court. I ain't going. Is there some reason why I can't have what the Constitution protects? This is the only court. The common law court of record is the only court that the United States Supreme Court protects and secures for the rights of the people. There is no other court that is protected by this U.S. government or by the state. Is there some ungodly reason why I can't have what the Constitution protects and secures for me? That's what I tell them. Well, this is true.
What?
Do you have a comment on how you change your standing when you're in bankruptcy? Do you just...
You just a whole new case. You start a whole new pleading, a whole new case, a whole new suit, a whole new everything. I get so far away from their silly nonsense. The only thing I refer them to is the man who's interfering with my rights is some guy named a magistrate, judge, head clerk Smith, and some prosecuting guy who says he works in the Attorney General's office. Read my lawsuit. I put it on Andrew's website. See how I stylized it. See how I explained how they're wrongdoers. They're not defendants. They're wrongdoers. You won't see the word defendant anywhere in my lawsuit. They did me wrong. I want to be compensated for the wrong. Am I fighting these men? No. If I was fighting them, I'd say, put up your dukes, defend yourself. I don't want to fight them. I'm telling them, you did me wrong, I want compensation. And if they say no, you know what? I'm turning to the jury. Jury, did these people do me wrong? Yes. You tell them to give me money now. Okay, give this man money. I'm not fighting this man. I'm not bringing the controversy to the public. I'm not calling them defendants. I'm not fighting these men. I'm bringing my case, my claim, before a jury. And I'm telling them, pleading my heart out to the jury, look, these men did me wrong. I want to be compensated for the wrongdoings that these men did to me. Please tell these men to stop doing the wrong they're doing to me and compensate me $10,000 a day for every time they did it to me. Now, if you think that's excessive, jury, don't give me so much. Give me $1. I don't care, but tell these men to stop doing what they're doing, please. And that's the way I word it. You see the cover of my lawsuit. I don't put the letter V in there. I just put a black straight line between the parties' names. And I put myself as the prosecutor, and everybody underneath me is a wrongdoer. They did me wrong.
Now you file that in federal district court and demand it trial by jury.
That's it. Absolutely. Look at the cover. It's really simple the way I stylized it. I used Blackstone's Commentary, Volume 3, Chapter 23, Section 378, where it said that the jury at its own hazard and its own peril gets to determine the delicate matters of law and fact, and then once it's tried, either for the plaintiff or defendant, that verdict is final. That's it.
I want to get a copy of that. That sounds like a good template.
Simple template, beyond simple. Any of their codes, if you want to refer to their codes, use the letter CF, like Cactus Frank. You gotta learn what CF means. It's like, not only do I believe what they did is wrong, but CF, Title 42, Section 1983 says that they can't interfere with the rights of the citizens of the United States. Now, I'm not saying I'm a citizen of the United States, but they know that what they're doing as a public official, they can't even do it to the citizens of the United States. I'm not saying that, but I'm just comparing it to me as a man. They can't do what they did to me. So always compare what they did wrong to you to what the United States Supreme Court agrees is what's wrong, what the state statutes say is wrong, what the citation of the Bible says is wrong to you, but you always use CF. Like if you look at my lawsuit, you say, wow, he's got CF like everywhere. Compare that to United States Supreme Court ruling in Plastic versus CIA. Look at that as compare that to Blackstone's commentary. Look at that compared to Alabama Code of 1955, Section 36.1, 36.5. Compare that with. They are not allowed to do that, even under their own laws. It's not only my belief, it's their law that they're also in violation of. They're interfering with my right, and they're also in violation of their own law, of their own codes, of their own ordinances. They're in violation of their own nonsense that they write. You see how I stylize it? But you can always